Yes, knocking out a tooth, cracking a tooth could be serious bodily injury. There are an equal number of cases that say, no, it's not. Ultimately, it's a jury answer. What I was finding in my research, though, is all these people who had their teeth knocked out where it was considered a use of serious bodily injury, they all seem to be holding like weapons. We are the Armed Attorneys. Today we are answering your questions. We got some good ones. Black powder defense, paint bombs for porch pirates, how all these new ATF rules interact with Chevron deference being kicked down, shockwave carry, and so much more. But before we begin, show your support for the Second Amendment by hitting that like button. And Texans, head over to armedattorneys.com. Check out the Armed Attorneys Self-Defense Legal Protection Program. This is that thing that probably is itching in the back of your mind. You know you need coverage. These things, self-defense incidents, first they charge you criminally, then they sue you civilly. You don't want to get wiped out by this stuff. And we have a solution for you, so check us out, armedattorneys.com. Emily Taylor.
Hello.
We got some good, hopefully we have some answers to your questions today.
All right.
All right, the first one is Cicely Michael. Question, curious if you folks have ever defended someone who used a cap and ball black powder firearm.
No. And funny, because people do ask about them quite a bit. And actually in years back, it was a popular device for getting around our open carry statute for some time before we had open carry. So it was something that was a little bit more popular, but no, I have never ever. I mean, gosh,
You've had a single action revolver person.
I've had a single
That's as close to black.
Yeah, that's as close as we've ever got. Well, and I had M1 Grand Guy. That's the most unusual firearm.
I've had some black powder felon in possession, not technically a firearm under Texas law. So obviously those cases go away.
Oh, we had a black powder TSA violation once. You remember that?
Yes.
And that was interesting because normally you accidentally carry your handgun through TSA security and you carry on, and it's pretty much strict liability and there's not much you can do. But the one time you really get out of it is when you're like, hey, this wasn't a firearm. And then there are other statutes that
they still hate it,
but it's not a firearm.
Right.
And you'll be in trouble for something else, but not firearm.
Yep.
All right. So we've got at Anthony Guardian Survival Tools question.
Anthony always has great questions.
Anthony does have good questions. Can you please give some examples of when what is clearly written in the law as justified conduct for self-defenders does not work out for the defender in reality because the court or jury dishonors, ignores, manipulates, or misinterprets the laws versus reality? Seems I've heard of an example of someone protecting a third party that shot and killed an attacker who was attacking a woman at gunpoint, but one round missed the attacker and also killed another innocent woman. And although that does not fit the legal definition of reckless, they were still charged with manslaughter.
Yeah, so this is tough. And, I would love in my, heart of hearts, because I love a process. But, when juries go back and they deliberate, was this justified? Was it reasonable, immediately necessary? Was the amount of force used the right amount of force? You'd like to think they take the facts that they've been presented, crank it through the law, and come out with a clean answer. But really, from what I've seen, juries rely on their gut a lot more of like who's right and who's wrong. And I think it comes down to reasonableness.
Well, yeah, that's where you can't create a perfect machine like Richard wants to create, because reasonableness, although you're supposed to use an objective standard, a hypothetical reasonable person, that's just not how human beings on a jury work. They're always going to say, who do I think was right? Do I think that was reasonable? Not the standard they're supposed to apply, but that's where it gunks everything up. So yes, I mean, there are countless examples, because the state's going to arrest you and prosecute you regardless. But there are countless examples of that working against you when the law says you can do a thing, but ultimately, I mean, oh my gosh, Edwin and Leslie are about to go to trial on one where the law says you can brandish a firearm to rid yourself of a trespasser. The law says it, but it's got to be reasonable. And I am worried about how this trial is going to turn out.
Well, and I've seen it go the other way too. And this is why, it's always down to this jury. What is the jury going to do? I've seen examples where, and you hear us say this all the time, warning shots, not a thing, because it's a use of deadly force. But at the same time, you're kind of saying, hey, this isn't reasonable or immediately necessary because I had time to point it in a safe direction. So generally, we say warning shots, terrible decision. But I had a client who, there's a giant brawl in front of her house. One of her family members was getting their egg kicked, and she discharged in the ground because that was the only way to get the attention of a huge group of people. Now, in that situation, all right, I would normally say don't warning shot. But jury, this is one of those things where they say, hey, this is reasonable under the circumstances, even though the law. So
interesting. Law said no, but the jury muck up was in her favor.
yeah, so I've seen it go both ways.
Sure enough.
All right, this one to you, Emily. Rob Holland, 2722 question. You have discussed Texas law concerning truck guns via pistol, via long gun. My question is about a firearm such as the Mossberg Shockwave. Since it is neither a pistol nor a rifle, must it be concealed or can it be carried in plain sight?
That is an excellent question. It is a firearm. You're correct. It is neither pistol nor rifle. However, because it is not pistol, it need not be concealed or, if visible in a holster. You can treat it like a long gun. Treat it like a long gun. All bets are off, except don't commit disorderly conduct. Don't display it in a manner calculated to alarm.
Yeah, so in Texas, no holster requirement, but yeah, exactly right. The only law that when we talk about carrying long guns generally out in public or just firearms generally out in public, that's what we look at, our disorderly conduct.
Yep. All right, we've got at Rick Lobrecht. Question, when being attacked by someone using their hands and feet, no external weapon, what separates bodily injury from serious bodily injury? My son was attacked and the first punch to the face broke a tooth. Would this have justified a response with deadly force or just force?
I went digging on the law.
You forced Richard to do a bunch of research
I did.
Into teeth.
Yes, and I'll tell you, I don't really have good news to report. There are cases where they say, yes, knocking out a tooth, cracking a tooth could be serious bodily injury. There are an equal number of cases that say, no, it's not. Ultimately, it's a jury answer. What I was finding in my research, though, is all these people who had their teeth knocked out where it was considered a use of serious bodily injury, they all seem to be holding like weapons, like blunt part of an axe or club or something else. And so that makes me lean towards maybe a punch to the face by itself, cracking a tooth, breaking a tooth. I'm going to say it's a jury question ultimately, but the case law does not seem to be in the favor of that being by itself, absent other factors, like let's say you break a cheekbone or orbital socket or a jaw or something like that. Tooth by itself, I don't know. But there was one case where somebody got their tooth knocked out. They were knocked unconscious in the court. There was a case where they said that was serious bodily injury. So you see how all these different things can change it.
Yeah, ultimately, you want to use deadly force, you're going to have to take that punch and then be able to say to the jury and have it be reasonable that you thought you were going to die. And in some cases, that's going to be very much true. I mean, if someone punches me in the face and knocks a tooth out, like I'm going to assume that they're ready to kill me.
Should we put that on the thumbnail, you with one tooth missing?
No.
All right, we won't do that. All right, this one to you, Emily. John Zian, 5RO. Not a gun question, but people who trap porch pirates using paint bombs, etc., are they within the law?
So I love these videos as much as anyone because porch pirates deserve it, like with the glitter bombs and the fart bombs and everything.
Yeah.
Yes. Phenomenal. Yes, you are within the law. So we're talking Texas here because that's where we are, but we actually have a specific code section that talks about devices to protect property, and it is section 9.44 of the Texas Penal Code. And here this is when it is acceptable, and we've got two conditions here. Number one, the device is not designed to cause or known by the actor to create a substantial risk of causing death or serious bodily injury, and the use of the device is reasonable under all the circumstances as the actor reasonably believes them to be when he installs the device. So, until...
Not a lot of cases on this also.
Not a lot of cases on this, but until you can die from fart spray, and you were reasonable in believing that that is true,
Sure.
Fine. Go on with it.
Yeah, and then just looking into the common law just a little bit, generally they do not like devices to protect stuff because there's no human input of like, hey, judgment call, is this an appropriate use of force?
Yeah.
Deadly force, never. I've never seen a state legalize traps for deadly force. But for the use of force, they still want some human judgment involved so they can hold somebody responsible.
You think that we can start programming our Ring doorbell cameras with AIs to decide who our houses could shoot with trap guns?
Oh, yeah, I've seen it.
Spring guns?
Sure.
Yeah, there's some judgment in there. Okay, and last one. This is at Spoperquimix1. Please, please, please. I am literally begging anyone with knowledge to explain to me how any new rule made by any NGO has any legal effect on anyone since SCOTUS reversed Chevron deference. In other words, does this new rule you guys talked about have any legal standing now that Chevron deference is dead? So we talked about our new rule on shipping guns.
I'm gonna fill in. I'm sure he's talking about not the Congress passing a law, but one of our government agencies.
Right.
And this was in the context of the proposed rule, so that FFLs using remote verification could ship a firearm directly to consumer, through the mail. All right. So the question is, Chevron, what did that do? Well, it left agencies up to interpret their own rules, and the court sided with them if the statute was ambiguous. Hint, they used to think all their statutes were ambiguous, and it gave them the
So
authority.
much more power.
Yeah, power. I'm making lots of air quotes if you're just listening. To write all kinds of stuff that clearly the Congress either expressly disavowed or didn't have the authority to do, or if they did it, it did the exact opposite of what the agency wanted. And so now the question becomes, all right, you would think all this rulemaking under all these agencies, is it defunct just because Chevron is dead? And the short answer is no. What Chevron did is it shifted the calculation from the agencies self-interpreting, and it shifts it to the judicial branch. So if the rule is going to survive judicial scrutiny, is this within the scope of what the Congress is allowed to do? Did they regulate this area, and did they delegate things? If it jumps through, a bunch of these hoops, and yeah, the rule's going to be okay, but the calculations with the court and not the agency.
Right. Loper Bright. I wish Loper Bright had said, you can't make rules anymore. But
yeah,
Loper
wouldn't
Bright
that
just,
be fantastic?
Be amazing. Loper Bright just said, you don't get to be judge, jury, and executioner of ambiguous law anymore. Really.
Yeah. You just get to be the
judge and jury.
Yeah.
The court's the executioner. I don't know. Anyway.
I'll figure out where they fit in that analogy. But these are some great questions, and we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And if you are not an Armed Attorney member, leave your questions below, and hopefully we'll get to them on a future episode. If you are an Armed Attorneys member, you can submit them to us directly, and we will call you and talk about them. So if you're a Texan and you like that, go on over to armedattorneys.com. And until next time, we're the Armed Attorneys.